Hey everybody, Scott Wells here again with your second installment on a three-part series on the use of force. Today's presentation is primarily going to focus on the use of deadly force. We're going to look first at a couple of RCW definitions that I touched on in the first installment, those being the definition of necessary and the definition of deadly force in the state of Washington. That necessarily carries with it a review of Tennessee versus Garner, and also another case that I thought would be interesting to look at in Forrett v. Richardson, which is also a Ninth Circuit case that came to us in 1997, and it regarded the flight of a fleeing felon. The flight involved a couple hours worth of flight by a felon who committed some pretty egregious violent acts. And so I just wanted to touch on some of those things as well in light of Garner. And Tennessee versus Garner, there's a case called Scott versus Harris that specifically says that Garner doesn't establish a magical on and off switch that triggers these rigid preconditions for using deadly force. What Garner gave us were examples of when force may be considered reasonable, or I should say deadly force may be considered reasonable. In each case, said the justices who decided that case, we must slosh our way through the fact-bound morass of reasonableness. So it's on a case-by-case basis based on totality, really, and an example of the objective reasonableness standard that Garner gives us. So we're going to look at that in depth and some other things as well. So thank you for tuning in, and let's get started. The first definition I'd like to take a look at is the definition of necessary. Now, Washington does a really good job actually in giving officers a clear definition of what they mean by necessary. And I'll kind of explain that here because California had two bills pass under Gavin Newsom, and it is now the most restrictive state use of force law in the nation. And what they are doing there, just so you can kind of put this in context a little bit, is they've gone away from the objective reasonableness standard. States can do that. States can be more restrictive on governmental action, and so they did. And by that, they're going away from the definition or the objective reasonableness standard, I should say. Could an objectively reasonable officer come to the same or similar conclusions under the same or similar circumstances regarding the use of deadly force? So they're going away from that to a necessary standard, which means was it reasonably necessary, the application of deadly force? But they don't define what necessary means. I haven't been able to find anywhere in, and actually they acknowledge as much in some publications that I read, that they don't have a clear definition of necessary. And so I think Washington does a really good job for us in that regard. And we all know from our academy experience, and there is no change here in the definition of necessary, that there is no reasonably effective alternative to the use of force that appeared to exist. Now note that it says reasonably effective alternatives. It doesn't say all alternatives because the court understands that there are times when, not every time, but there are certainly circumstances in which an officer works in conditions that are tense, uncertain, and rapidly evolving. And so time is limited to make these very, very important decisions. So they're looking for the reasonably effective alternatives. And did they exist, or did it exist? And was that amount of force that was used, was it reasonable? Was it objectively reasonable to effect the lawful purpose intended? Washington State is still there. So with that, let's look at the definition of deadly force in the state of Washington. And it means the intentional application of force through the use of firearms or any other means reasonably likely to cause death or serious physical injury. Now, we know that if deadly force applies based on totality, then it really doesn't matter the means in which it's delivered. Firearms or any other means reasonably likely to cause death or serious physical injury. And so the courts really aren't concerned with the type or the style of force that's used. They don't necessarily care if it's karate or Krav Maga or Muay Thai. They're just looking at, was it objectively reasonable? So sometimes I think we get wrapped up around the axle on styles and systems and things like that. And it's really not looking at that. What they're really looking at is, was it objectively reasonable under totality? So let's look at RCW 9A16040, justifiable homicide or use of deadly force by a police officer or a person aiding, and what the good faith standard actually means, what they define it in Washington state now with the current law. And so homicide or the use of deadly force is justifiable in the following cases. Subsection A, when a public officer applies deadly force in obedience to the judgment of a competent court. So what that makes me think this means is that a competent court could decide that based on the crime, if the subject has been convicted in the state of Washington for a very serious offense, is I believe how they define it, that person could be eligible for the death penalty. Now we know since 2018, the state does not employ the death penalty in cases because they found that there's no penological interest in the reduction of crime or prevention of crime based on having the death penalty applied in the state. Also, because it ran aground of Article 1, Section 14 of the Washington State Constitution, which addresses excessive fines, bails, and punishment. When necessarily used by a peace officer, again, you see that definition there, necessarily, and I'd ask you just to keep that in mind as to what the definition of necessary is. But meeting the good faith standard, and I'm going to go into what Washington now defines as good faith in our state law, to overcome actual resistance to the execution of the legal process, mandate, or order of a court or officer in the discharge of a legal duty. Continuing on with the aspects of 9A16040, justifiable homicide or the use of deadly force by police. Subsection C, when necessarily, again, there we see necessary, used by a peace officer meeting the good faith standard of this section or a person acting under the officer's command or in the officer's aid. 2, arrest or apprehend a person who the officer reasonably believes has committed, has attempted to commit, is attempting, or is attempting to commit a felony. Now, does the use of deadly force apply just to felonies? No. It's going to depend on totality, because we can all agree that a crime that we initially believe to be of a misdemeanor level can escalate very quickly to felony crime. So that can occur. Subsection 2, to prevent the escape of a person from a federal or state correctional facility, or in retaking a person who escapes from such a facility. Subsection 3, to prevent the escape of a person from a county or city jail or a holding facility if the person has been arrested for or charged with or convicted of a felony, or to lawfully suppress a riot if the actor or another participant is armed with a deadly weapon. Continuing on with 9A16040, when we're considering the use of deadly force under subsection 1C, which was on the prior slide, which was really to arrest or apprehend any person for the commission of any crime, because we know that misdemeanor crime can evolve very rapidly to felony crime. The peace officer must have probable cause. The standard is PC. It is not reasonable suspicion. It is a PC standard to believe that if not apprehended, the suspect poses a threat of serious physical harm to the officer or a threat of serious physical harm to others. And the standard is PC, so I'd ask you to go back to the definition of probable cause, that the same one we teach the recruits is, are there articulable facts and circumstances known to the officer or reasonably known to the officer at the time that would lead them to believe that this subject committed this particular crime? And so the standard is really the same. It's a PC standard. So among the circumstances which may be considered by peace officers as a threat of serious crime are the following, and I think you're going to see that this is where Washington law and their definition of when justifiable homicide or use of deadly force by a police officer aligns very squarely with Tennessee versus Garner in those conditions and criteria. So we're going to look at those conditions in which the state also says that it would be reasonable for an officer to employ deadly force. And I think these are going to look very familiar to you, and they should look familiar to you because they square up exactly with the criteria in Garner. The suspect threatens a peace officer with a weapon or displays a weapon in a manner that could reasonably be construed as threatening, or There's probable cause. Again, the standard is probable cause standard to believe that the suspect has committed any crime involving the infliction or threatened infliction. So whether it's actual, they actually did this, or it was threatened of serious physical harm. And under these circumstances, deadly force may also be used if necessary to prevent the escape. If feasible, some warning is given. Now, we know that it's not always feasible to issue a warning, but it will never hurt the officer's use of force, and provided that the officer is meeting the good faith standard. So let's take a look at what the good faith standard is in Washington. So we've mentioned the good faith standard a couple of times here. So let's take a look at what the state defines as good faith. And I think it's also going to look very familiar to you from our reviews of Tennessee versus Garner and Graham. But a public officer covered by Section 1A of this section shall not be held criminally liable for using deadly force without malice, because we know that the subjective belief of the officer really is irrelevant. Was it objectively reasonable? And with a good faith belief that the act was justifiable pursuant to this section. So what do they mean by good faith? And so, again, they say that a police officer shall not be held criminally liable, or a peace officer shall not be held criminally liable for using deadly force in good faith, where it's an objective standard. It is not subjective. It is based on facts. We know that facts is what makes force reasonable. So facts, circumstances, and information known to the officer at the time to determine whether a similarly situated reasonable officer would have believed that the use of deadly force was necessary to prevent death or serious physical harm to the officer or another individual. So I would go back to the definition of necessary. Were there reasonably effective alternatives to the use of force? Objectively reasonable alternatives, not all, but were they objectively reasonable alternatives to the use of force to effect the lawful purpose intended? So that's what good faith means. Good faith really is the objective reasonableness standard. Just to reiterate some of the points that we're talking on here, the general rule is that the more intrusive the seizure, the stronger the governmental interest should be for effecting it. And the Supreme Court said this. They said in Garner that the use of deadly force is unmatched, meaning there's nothing like it. And since it's an ultimate seizure of somebody, and we're talking about lives here, there should be a very compelling governmental interest for using it. So that when you look at that in light of Graham, and you look at the Graham factors, of course, immediate threat is deemed the most well-respected of the Graham factors, but severity of crime also speaks directly to a compelling governmental interest for using it. And over the years, it's been pretty clearly established that deadly force is a reasonable force option when the officer has PC. Again, there's the PC standard to believe that the suspect poses this immediate threat of death or serious bodily harm to the officer or others. Now, sometimes you'll hear people talk about the immediate threat regarding deadly force. Sometimes you'll hear people say imminent threat. The courts really used the word in Garner. They used the exact word of significant threat. So does that mean immediate or imminent? And what it's really talking about, in my opinion, is based on totality. And of course, regarding warnings, while a warning adds to the reasonableness of any force option, deadly or not, it's not always feasible. There's not always time to issue a warning. But the courts say that we should when it's feasible. So since we're talking about Garner and we're making a lot of reference to it, let's take a look at it. And so just a little bit of background. Garner was a 6-3 majority decision delivered by Justice Byron White. So it wasn't a Rehnquist court that ruled on this. And the court labeled the Garner shooting a seizure under the Fourth Amendment, the ultimate seizure. Again, it's unmatched. And what this did was it allowed the court to consider whether the use of deadly force was reasonable when considering the totality, of the circumstances. So the first issue that the court really looked at and focused on was whether Garner posed a threat to the officers. And Justice White wrote, where the suspect poses no immediate threat to the officer and no threat to others, the harm resulting from the failure to apprehend him didn't justify the use of deadly force to do so. And so we know that the officer involved in this case relied on a Tennessee state statute that authorized the use of deadly force on any fleeing felon, period, without articulation of immediate threat. And so the courts came back later and ruled that in Garner that that's unconstitutional. And so, continuing on with what Justice White said, he said, it's no doubt it's unfortunate when a suspect who is in your sight escapes, but the fact that the police arrive a little bit late to the incident or are a little bit slower afoot does not justify killing the suspect. It's not better that all felons die than that they escape, which means sometimes they get away. So the Supreme Court's decision in Tennessee versus Garner gives good examples of when a police officer may use a firearm to seize someone. And it started off as a complaint about a burglary in progress. A neighbor, I believe, was calling in a burglary of a neighbor's residence. So police have arrived, 2 police officers arrived, and they responded to the scene. And one of them sees Garner, who is the suspect, run out of the house. Now, Edward Garner was 15 years old, but he looked older to the officer. But what the officer described was Garner as a 17 or 18-year-old male, about 5'5" to 5'7", and he saw no sign. He said he was reasonably sure that Garner was not carrying a weapon, was unarmed, and based on the facts, was reasonably sure he wasn't armed. So what happened? In Garner, the police see him at the fence, and the officer yelled, "Police, halt!" But Garner kept running away. He kept presenting flight. And so when Garner started to climb over the fence, the officer believed he only had 2 options. The first option was he could let him escape, or he could use deadly force to stop him. And so, like I said in the first slide, just previous to this, the officer relied on that Tennessee state statute that was later deemed unconstitutional by the Supreme Court. And that Tennessee state statute allowed police officers to use all necessary force to effect the arrest of a fleeing felon, period. No articulation of immediate or imminent or significant threat whatsoever. So the officer did what he thought was necessary, and he shoots Garner, and he shoots him in the back of the head. And unfortunately, Garner dies on the operating table. And now the officer couldn't have known this, but Garner was found with a purse and I believe $10 in cash. And so now we have this result over a felony crime, but over a purse and $10. So the officer couldn't have known that, but again, what was the immediate threat is what the courts were focusing on. And so what happened in the ruling? What was the result? And the courts looked at it and said, well, deadly force is the ultimate seizure. It's unmatched. And so they ruled that that Tennessee state statute was unconstitutional because it authorized the use of deadly force to stop a fleeing suspect who posed no immediate threat. And Justice White specifically said it's not better that all felony suspects die than that they escape, said the court, meaning sometimes they get away. And they concluded that deadly force may not be used unless it is necessary. And again, Washington does a good job on defining necessary for us to prevent the escape. And the officer had probable cause to believe that the suspect posed a significant threat of death or serious physical injury to the officer or others. So if we look at the situation in Garner, the officer himself stated that he reasonably believed the suspect was unarmed. And yes, we're talking about a felony crime, but what was the immediate threat to anybody at that moment in time? And there wasn't one. And so that is what the courts are looking at when they're talking about the totality. So to wrap up Garner, it followed that deadly force is authorized when the officer can articulate facts rising to probable cause, more likely than not based on facts, circumstances, and information that's known to the officer, that the suspect poses an immediate threat of death or serious bodily harm either to the officer or others. And again, just to talk about warnings again, the court said the issuance of a warning should precede the use of deadly force when feasible, but we know that it's not always feasible. But again, it will never hurt your use of force. And it's really Graham where we get the objective reasonableness standard from. So in light of that, the officer is going to be judged from the perspective of a reasonable officer on scene. And that goes directly back to Washington State's definition of good faith. It's an objective standard based on fact and circumstances and information known to the officer at the time. This next case we're going to talk about here actually occurred in 1990. It was ruled on in 1997 in Forrett versus Richardson, and it involves felony crime, and it involves flight of a suspect, and it involves the multiple applications actually, of deadly force by officers And so let's take a look at it. And as we walk through it here, I would just ask that you consider, based on totality, on what the officers knew, was what they ultimately did, was it objectively reasonable? So Forrett committed a very violent residential burglary at about 12 o'clock p.m. in November of 1990. And while he's in the residence committing the crime, he encountered victims. He tied up 3 of them. He subdued all of them. And he actually shot one in the neck at point blank range. And then he shoots another using a .38 that he found inside of the house. So he flees the scene in a truck owned by one of the victims, and he takes several firearms with him and about 250 rounds of ammunition. So after the commission of the crime, he flees. He leaves the house in the stolen pickup truck, and one of the victims surprisingly manages to untie himself, and he calls Riverside Police. And he relays this information to the dispatcher, which ultimately gets promptly relayed to the police. And the victim gives Forrett's physical description. He lists the crimes. He describes the truck that is in flight and the fact that stolen weapons were taken in the commission of the crime. So the officers had this information. These details were promptly relayed via police radio to all the units in the area. And so this is known information. This isn't information that was discovered after the fact, because we know that would be irrelevant to the use of force, but they knew this. So the officers began to search for Forrett, and they find the truck within about an hour, and Forrett is not present, and neither are the weapons. So we have an outstanding suspect, very violent crime, and the weapons that were taken in the commission of the crime are not located inside the truck. So really the only reasonable conclusion is that Forrett is still armed. So after they find the truck, a few minutes later, another officer, Officer Kenneth Rea, he sees Forrett walking in a nearby residential neighborhood. And because Forrett matches the suspect description, Officer Rea confronts him. And we know that officers can use reasonable force when effecting a Terry stop. And so we have Forrett in the area, matches the suspect description. He's in proximity to the crime. So he makes this confrontation with him, and while doing so, Forrett flees into a residential neighborhood on foot. And again, knowing that the level of the crimes involved, and knowing that the suspect vehicle was found without the presence of weapons, again, the reasonable conclusion is that he is armed. And so he runs out of view behind a residence. And so good tactics here. Officer Rea fears that Forrett is armed, and reasonably so, and might be setting up an ambush for him, so he waits for cover and support officers to continue his pursuit of Forrett. And while this is happening, a perimeter is being established, and containment is getting set, and helo and air support are coming into the area. And residents and nearby schools are warned to stay inside because the concern on the behavior reported that Forrett may very well take hostages, and these are all very reasonable conclusions to be coming to. So continuing on with this, Forrett, the suspect, eludes capture for nearly an hour. He's running across yards, he's jumping fences, and all this is taking place. And Forrett hides in a woodshed where he removes articles of clothing to alter his appearance. So 4 responding officers, they chase Forrett into a nearby yard. And here we are again, bounded on one side by a 6-foot fence. And this is really the only way this is similar to Garner, is that it involves a moment in where the decision to use deadly force is employed involving a fence. That's really where it's only similar. So they approach Officer Forrett to within about 20 to 30 feet, and they're ordering him to stop and surrender, and he's not. He's not complying with police presence. Heavy police presence is having no effect on his behavior or his flight. Verbal commands not working. Display of force option, firearms not working. And so it's not stopping his flight. So as Forrett hesitated, 2 of the officers fire 7 to 8 shots, and they miss him. And so ignoring the shots, Forrett ran to the fence and began to climb it into the adjoining yard. So all of these things are not having any effect on Forrett's flight. And at that point, they fire additional shots and they miss him again. So after missing Forrett after a volley of shots fired, he climbs over the fence, and the officers fired through the fence. They strike Forrett 2 times in the back and the hip, and it immobilizes him. He can't flee any further, so he's unable to run, and he's quickly captured by another officer who had come around the opposing side of the fence. And thank goodness we had some discipline here because we could have seen a fratricide incident here. And in total, the officers had fired approximately 24 rounds in total to stop Forrett's flight. So the question is, based on totality and what the officers reasonably knew, what were the facts, circumstances, and information that the officers knew up to the decision to employ deadly force, and was that decision objectively reasonable based on that totality? So the courts relied on, and they looked back at the cases of Graham and Garner. And under the Fourth Amendment, the police can use force that is objectively reasonable under the circumstances, and the objective reasonableness standard really comes to us from Graham. To prevent the escape of a felony suspect, we certainly have that. We certainly have egregious felony crime here. The suspect's in flight, and a police officer may use deadly force only when it is necessary to prevent the escape, and the officer has PC. Did the officers have probable cause to believe that the suspect posed a threat of serious harm either to the officer or others? And that comes to us from Garner. So the court first addresses what it means for a felony suspect to pose a threat of serious harm. And so contrary to Forrett's argument, the suspect need not be armed or pose an immediate threat to the officer or others at the time of the shooting. It's based on totality of the circumstances. The Supreme Court and Garner identified these specific situations. They gave us examples in which a fleeing felony suspect might be deemed or may be deemed to pose a threat of serious harm to the officer or others. So if we look at Forrett, was it present? Did we have it? So the Forrett court ruled that where the officer has probable cause to believe that the suspect poses a threat of serious physical harm, we know that we have very egregious conduct, very serious offenses involved in this, and we have flight. And with that, does that carry over to threat of harm to the officer or others? And the court said it's not constitutionally unreasonable to stop or to prevent escape through using deadly force. So if the suspect threatens the officer with a weapon, or there is probable cause to believe that the suspect has committed a crime involving the infliction or threatened infliction of serious physical harm, deadly force may be used if necessary to prevent escape. And again, if feasible, some warning is given. So I would say let's go back to what Washington's definition of good faith is. And initially, I think some people were upset and frightened with potential change in the law, when really it's what we've been teaching all along, at least ever since I've been in law enforcement, which is close to coming up to 23 years. And so it really shouldn't frighten anybody. It shouldn't scare anybody with the definition of good faith. So really the only remaining issue for the court in this case to consider in light of Garner and flight and the application of deadly force was it necessary under the totality to employ deadly force to stop Forrett's escape? And the court said the necessity inquiry is a factual one, and the real question was there a reasonable non-deadly alternative that existed for stopping him? And they looked at Brower versus County of Inyo in this, but if we think about it, there were many types of force that were employed, all the way up to deadly force in this case, that had no bearing, had no effect on his flight or his behavior. There was high levels of police presence, there were verbal commands, there was displays of force options, none of which were working. And as a matter of fact, the officers employed deadly force at the fence. They happened to have missed on the first and second volleys as he's climbing over the fence, but none of those were working. So was there any reasonable non-deadly alternative to stop him? And so no, there wasn't. The Fourth Amendment doesn't require law enforcement officers to exhaust every alternative before using justifiable deadly force. Now, not to say that this isn't a very serious consideration, and there should be a very compelling governmental interest in the application of deadly force, but in these circumstances and under the totality in this case, there was a very high governmental interest in stopping his flight and apprehending him. And so Forrett would have had that, and he did argue that law enforcement officers have to consider all alternatives, and the Fourth Amendment doesn't require that, nor does Washington State, because Washington State aligns very squarely with the Fourth Amendment in this regard. Also, issues of time, when we're talking about the alternative to the use of deadly force, that alternative has to reasonably likely to lead to their apprehension before they can cause further harm. So we have this suspect who's in flight for an hour plus, and during that time frame, what's the alternative to stop him before he can cause further harm? Now, we know he already committed essentially a home invasion burglary where he attempted to murder one party and committed another act of shooting another participant or victim in the crime in his flight. And we know that he stole firearms and ammunition. So it wasn't as Forrett would have had it. He wanted the consideration of any alternative that would have led to his apprehension in the future. So no, that's not what the Fourth Amendment requires, and nor is that what Washington State requires. So as it turns out, timing is absolutely crucial to apprehension in this case. So the timing of a suspect's capture, said the court, and the opportunities for violence that the suspect has before they are captured are therefore crucial to the necessity inquiry, the reasonable necessity inquiry of the application of deadly force. The use of deadly force to capture a felony suspect, not justifiable unless the actor, and the officer in this case, has probable cause to believe that there is a substantial risk that the person who we are after, in pursuit of, will cause death or serious bodily injury if that apprehension is delayed. So if we think about it, Forrett is on the run for an hour plus, probable cause to believe that he's armed. We know that we have probable cause to believe that he committed very egregious, serious offenses. He's jumping fences in a populated area. And is there a probable cause standard to believe that if not apprehended, this person whose flight is not hindered in any way by significant varying levels of force, does that exist? And in this case, yes, it absolutely did. So what was undisputed in this case, it's not just me saying this, but the courts found this, is that these facts were undisputed. Forrett used every desperate means at his disposal to elude capture for an hour of hot pursuit. And we know from our criminal procedures that hot pursuit is one of the four prongs of exigent circumstances. He vaulted fences, he hid in a shed, he removed easily identifiable clothing, also to stall out his apprehension. He ignored officers' verbal commands to stop, so not only presence and display of force options, but he ignored verbal commands. He ran to the fence despite deadly force being employed on him, and still failed to surrender. And despite that, he continued to run and continued to flee after they fired shots at him. So the only objectively reasonable conclusion to be drawn at that point was if they hadn't fired, he was going to continue taking whatever measures were necessary to avoid capture. So is there PC to believe that the suspect presents an imminent or immediate or significant threat of serious bodily injury or harm to others? And we know that he's already showed evidence of that. So what's the likelihood of him causing harm to another or taking a hostage? Probably pretty high, at least meets the probable cause standard for sure. So the officers had probable cause to believe that Forrett was willing to use violent means to achieve his ends. So in case law, out of the 11th Circuit, so not the 9th, but at least it exists in case law in Manuel v. City of Atlanta, it is acknowledged that a suspect or a potential arrestee who is not in custody, they're not physically subdued, they're not in control, nor are they compliantly yielding, they still remain capable of generating surprise, aggression, and death. And so did we have that in this case? And absolutely we did. And again, Forrett was contending that they should have considered any alternative that would have led to his apprehension in the future, and that's just not what the Fourth Amendment nor Washington state law requires. And the force option must be reasonable in light of the community's strong interest in security and preventing further harm. That's a Seventh Circuit ruling, but I would say, what is the governmental interest in this case, and is it low or is it high? And clearly, we have very high governmental interest in the investigation of this crime and the apprehension of Forrett. So to wrap this up and put this in context is, when is my use of force, in this instance, deadly force, objectively reasonable? And so I would put this up again. And I think this mnemonic or equation, whatever you'd like to call it, that Sean Hendrickson came up with is absolutely brilliant. And it really captures not only the Fourth Amendment's requirements, but Washington state laws too, because we know that the good faith definition is an objective inquiry. It's an objective analysis based on facts or totality. What were the facts, information, and circumstances known by the officer at the time? Now, we know that the Ninth Circuit tends to rewind the tape in the provocation doctrine, in which speaks again all the way back to patrol tactics and controlling of pace. And was it the officer who was pushing the pace or making something an issue that didn't have to be in the first place? So the police lawful use of force, again, just equals the objective reasonableness under totality based on the 6 situational factors, plus the factors in Graham, and the 3 types of force, and the plus again being pace control and the probable cause standard. So thank you again for your time. If you have any questions, feel free to shoot me over an email, and we can discuss it. Thank you.